Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go in the studio outside of Atlanta, Georgia. I'm Matt Staroziak. Got another episode of Military Justice Today on tap. Sitting across from me in the podcast studio is none other than Robert Capovilla. Hello, Robert.
Hey, Matt. It's good to see you. It's been a minute since we've been in the studio. It's always nice to get back in here and talk military justice matters.
It's great to see you, Robert. You look great. You've got a sports coat on. You got a Rolex watch. You're sporting some of the firm's logo on your apparel. You look great.
I wish this was a Rolex. It's actually a Bulova. It is a nice watch, though.
Is it?
Yeah, I have a. I drive the same pickup truck, Matt, that I've driven since we started the law firm all those years ago. I live in the same house, but I do have a tendency about once a year to go buy a really nice watch as a way of kind of rewarding myself. So I've got a couple of these, including one of my dad's watches that I really like. But yeah, it's a Bulova. I was at Fort Liberty a couple months ago, and I visited a friend in Charlotte, and I stayed in this kind of upscale part of Charlotte, and they had a Rolex store right next to my hotel. And I was considering going in and getting a Rolex, but then I decided, considering we just had our twin boys, I decided against doing that. So I went ahead forward with the Bulova. Well, it's still a great watch.
It's a good thing you did, because I think it's never just one Rolex from the guys I know that have bought them. It's always a Rolex and then a second Rolex or an upgraded Rolex. So
yeah.
And then we shouldn't forget, we've got Brad Simon on the call today as well. Brad, are you with us?
Yeah, I am. How are you?
Hey, man, we're doing great. How are you today?
I'm doing well. I'm looking down at my wrist and I'm wearing a plastic Casio. I am not wearing a Rolex by any means.
There you go. Well, hey, it'll do the job either way. So are you in Texas today?
I am, which is very nice to be home for a little bit here.
And is it warm there? It's super warm here today for February. Yeah. It's crazy.
It's like 80 degrees or will be 80 degrees today. I don't understand. 2 weeks ago, it was freezing. Now it's 80 degrees. I feel like it's almost pool weather. Texas is unbelievable at times.
Yeah, that's crazy. That's crazy. All right. Well, we've got a great episode today. You and Robert are pretty much going to go to work on the topic because it's quite technical, I believe.
Yeah, so I'm very excited about this episode. We're going to be talking about a 412 case called United States versus St. Jean. And I asked Brad to come in and talk about it because Brad is sort of our resident case law nerd, and he knows this stuff as well as anybody in America. And quite frankly, Brad and I have both had to litigate this very case in courtrooms across the DOD over the last couple years, and it seems to have popped up more, in the last year, obviously. And so it's a case where I've also seen some assigned counsel be asked by the military judges about, and I've not. They seem to think that it serves as some kind of bar, or they don't necessarily know how to answer the questions for the military judge. So I wanted to have this podcast to allow Brad, who's one of our big brains at Capovilla Williams, to discuss the holding of the case, the facts of the case, sort of the procedural history of the case, and then most importantly, talk about how do you argue this case as a defense lawyer in court during a 412 motion, because I see too many mistakes being made by our colleagues in how to actually argue this case. And so that's why we wanted to have this episode. It's an important episode, and I hope that folks will enjoy the analysis and sort of Brad's pointers about what to do and how to, for lack of a better term, overcome this particular holding. Does that about sum it up, Brad?
I couldn't say it more perfectly than that, Rob.
Good. Okay, so Brad, let's talk about St. Jean. Let's dive right into it. And first, let's start with the facts. What were some of the facts and sort of the procedural history that are the factual context to this case?
Absolutely. So St. Jean was a specialist in the Army stationed at Fort Sill. And this case it originates out of the Army, obviously, but the allegations go all the way back to 2018. So St. Jean, the alleged victim or the victim, and some friends were all hanging out in May of 2018. They went drinking in the barracks, and they wound back up St. Jean and the victim in his barracks room on the 4th and 5th of May. She wakes up to him penetrating her and claims that it was without consent. He goes to trial for this allegation and is unfortunately found guilty. Now, before we got to the actual trial, there was what's called an Article 39A, the motions hearing. And that's where the defense counsel tried to enter in that 412 evidence, the history between the victim and Specialist St. Jean. And some of the stuff that they tried to offer were 4 or 5 big things. It's one, the night before the incident, the two of them were in her room making out. That after the incident on the 4th of May, that the two witnesses saw St. Jean, Specialist St. Jean, with hickeys on his neck. That they also saw her in a fold-out bed with him the day after the incident or the morning of the incident. And that finally, she showed him a Polaroid with bruises on her buttocks, saying she liked to be spanked. So that's what they tried to offer at the motions hearing, Rob. And so that's kind of what the context of it as we got into the judge's ruling and the issues that later came up.
So let's talk about that next. Let's start at the trial level. What were the judge's rulings regarding those particular notices under 412?
And so the judge here, I want to make it known there's 2 different judges. So there's a motions judge and a trial judge, and that'll become important later on. But the motions judge denied the photo, denied the kissing on the 3rd of May, because the incident happened on the 4th of May, denied the kissing on the 3rd of May, denied hickeys being seen, and a spanking comment.
And what was the judge's rationale? What's kind of the background there in terms of why do you think the judge made that decision? Because obviously on the surface, that seems like proper 412. So what was the hangup? What led to this ruling by the judge?
Absolutely. So what really called the judge to do it was that even though there might be some relevance, some tenuous relevance, so they kissed the day before, or that there was some comment of showing of the buttocks and like to be spanked, the tenuous value was substantially outweighed by the prejudicial effect. Basically, what the judge said was that simply because someone made out with someone the day prior, that doesn't mean that they would have consented to consensual sex the next day. Also, saying that you like to have your buttocks spanked, that isn't sufficient to meet that they would have consented to sex. Now, the one thing the judge did say is that the hickeys would be what's called res gestae, meaning it came from the incident, if there's evidence to show that the hickeys occurred from that incident and not a prior kissing incident. Because what happened at the motions hearing is the appellant's counsel, the defense counsel, argued that the hickeys, there was 2 sets of hickeys that came from the kissing before and hickeys that came from that incident. And to support that was he entered an affidavit from his client, Specialist St. Jean, as well as 2 witnesses saying they saw hickeys the next day. And that's going to get more into our practice tip later on, Rob, about what you need to do and the difference between a motions hearing and trial, because the evidence is different and how you're going to be able to enter it to a jury. But basically, the judge's takeaway was, hey, simply because there's some history between these 2 people, that doesn't mean it automatically comes in, because Rule 412 is a rule of exclusion, not inclusion.
So at the talking about the trial level, and I know you're going to give your pointers later, but at the trial level, I've obviously had the pleasure of litigating 412, I don't know, maybe over 100 times in 100 different courtrooms across the DOD. And typically speaking, to admit evidence of prior sexual behavior, there's really two highways to get to admissibility. The first is consent, which really comes down to the similarities between the actions or the sexual contact that occurred on 3 May and then what occurred on 4 May, right? I mean, that's the general idea. And then the second, of course, is under the constitutional exception, which is mistake of fact as to consent. At the trial level, did the defense counsel argue both of those points, or just kind of briefly talk to us, what did they argue for admissibility here?
They argued both, in fact. They leaned more into the B3 exception, which is that constitutional exception, but did argue both, saying that they had a mistake of fact or consent because they made out the night before. It shows the history between the 2 of them. And then also the consent to show them on the bed the morning after negates that if she woke up to him being penetrated or her being penetrated and it wasn't wanted, she wouldn't have stayed in that bed. They leaned into both of those. But really what the judge took away was, I understand there's some relevance here, some connection, but you're not linking how making out the day prior is related to consenting to sex the next day. The judge says, takes a step further. You don't, the emotional effect that the jurors will hear that she likes to be a quote unquote almost abused, to have marks left on her buttocks and say she likes to be spanked. It's outweighed by that doesn't connect the two allegations together. So he made a ruling that the hickeys from the incident would be allowed as res gestae if there's evidence, and that they can be seen on the bed the next day. So they go into trial with that mindset and knowing, okay, we're not going to be able to talk about the buttocks. We're not going to be able to talk about the kissing the night before, but we can still go forward with those other two things.
I mean, Brad, doesn't that paint a false picture to the panel? I mean, doesn't that mean the defense counsel had to try the case in a vacuum that, in fact, was not consistent with the actual facts of the case?
Yes, and I agree 1,000%. I think this is where 412, it becomes up to the judge almost, and there is an abuse of discretion standard. But what the judge in this case leaned onto was Andrazi, which is a separate case, which basically is that the relevance of prior sexual activity between an accused and alleged victim is increased by the degree of its similarity to the charged conduct and whether the sexual activity is distinctive and unusual. So what it really does, I agree with you, Rob, is it doesn't allow the members to know that, hey, yes, kissing is different than sex. No one's going to say those are the same things. But it doesn't allow the members to know that 24 hours earlier, the two of them spent time all alone in her room making out, and she took him into her room. Without the members knowing that, it doesn't give context to say why on the 4th of May were they in his room together after drinking in his bed. I agree with you. It's not giving the full view. The members need to know. And we're not going to argue, hey, because they kissed, they likely had sex. But it shows the developments of their relationship. And I agree fully. By keeping that out, the members are having tunnel vision and aren't getting to see the full scope of evidence, which is necessary.
And isn't Andrazi, and I might be wrong about this because I don't have the case law in front of me, but Andrazi's the whipped cream case, right? Where there was some engagement, sexual kind of flirtation and behaviors with whipped cream, and talking about sexual matters that occurred before the actual charged offenses. And Andrazi, correct me if I'm wrong, CAF or its predecessor came down and said, yes, that's admissible.
I believe so. I will
some
say I don't
some of it was admissible and some of it wasn't, maybe.
Yes, exactly. It was because it had to be similar. There had to be distinctive, similar nature of it.
Okay. So the trial judge makes this decision, and it obviously goes to trial. And you said earlier in the conversation that the fact that there was a different judge at trial was meaningful. Talk about that and what happened at the actual trial.
So there's a different judge that gets the trial. And so during the actual litigation of this, the defense counsel starts to ask questions at trial that would elicit testimony about hickeys. And the government counsel objects. And the trial judge says, defense counsel, what is before me to tell that there's two sets of hickeys, or that these hickeys came from the incident? What evidence do we have? And remember, at the motions hearing, we had an affidavit and two witnesses. The defense counsel concedes and says, there's nothing before you at this time, Your Honor. However, I can move on and raise it again should the evidence come up. And why that's so significant is that this trial judge, unlike the motion judge, who essentially denied the first set of hickey and said the second is res gestae, this judge didn't deny it or didn't grant it, but just said, what evidence do you have? And by the defense counsel moving on, he basically waived that point. So it actually never got affirmatively denied or granted, which is quite significant.
But Brad, isn't the defense counsel protected there from a procedural standpoint because they did raise the issue during an Article 39 alpha and it was ruled not in their favor?
Well, the first set was not ruled in their favor. They claim that hickeys came from two different instances, the 3rd of May and the 4th of May. But that's different, though. And here's what I guess I'll lean a little into the practitioner tip, and then we'll come back to it later on, is at a motions hearing, you can enter an affidavit from your client. You can enter limited evidence to show that it's possible this occurred, because that's a different standard. It's not up to the judge to determine if it happened, but is it possible that it happened? When you get to actual trial, you now need to demonstrate or enter evidence. So if the alleged victim takes the stand and says, no, I never gave him a hickey, well, you're stuck with that answer. So now, even though it may have been deemed admissible, there's nothing before the court to say, oh, no, I previously allowed that. This is how it's going to happen. You now need to enter evidence. And by the defense counsel saying, okay, we'll come back to it, and never coming back to it, they never put in evidence of where these hickeys came from, or that the appellant, in this case, Special St. Jean, even had hickeys on his neck.
I see. Okay. So, Special St. Jean is convicted in part because the panel was not allowed to hear the history and the context of the relationship. And so this poor guy was convicted based on evidence in a vacuum only. And the case goes up on appeal. Go ahead and take it from there.
Yeah, so absolutely. So the St. Jean, Special St. Jean, was actually convicted of Article 120 and Article 107. They don't talk much about the Article 107, which is a false official, because the Army Court of Criminal Appeals, CCA, actually set aside and dismissed the Article 107. And therefore, they only affirmed the findings of the Article 120. So like we talked about in previous episodes, the US v. Mendoza, there you have the trial level, then you have the specific military appeal court, in this case, the Army Court of Criminal Appeals. And then above that is CAF, the Court of Appeals for the Armed Forces, which is kind of like the military Supreme Court. So it goes all the way up to the military Supreme Court in a sense. And they review the appeal, which is only for, hey, we weren't allowed to talk about hickeys, and we weren't allowed to talk about the kissing incident prior. Those are the two main issues that they brought up on appeal. And CAF determined that the judge ruled properly on the prior consensual kissing, leaning really heavily on the Andrazi case, that there wasn't a similarity between the two, that the evidence is unfairly prejudicial in the sense that the fact finder is likely to react emotionally rather than logically. And because the judge ruled this way, it becomes abuse of discretion standard. Now, for the other one, for the hickey incident, the issue here is, in a sense, the defense counsel waived it by stating we could move on from this and could possibly readdress it, and never readdressing it. It left CAF in a position to say, hey, we can't even review this because there was no denial or affirming it.
So
it was res gestae, but we never heard more about it.
So let's put aside for a second the hickeys, because that's res gestae. That may have been a mistake by the defense counsel. Lord knows we all make mistakes when we're in the heat of battle. It never goes exactly the way you want it to. Obviously, that's a fairly large mistake to make. That being said, let's focus on the kissing, because I want to share my thoughts here, and then I'd like you to kind of respond like you were the court, right? The court's reasoning. So I'm defense counsel, and here's my argument. Members of the court, or in this case, I guess a judge, right? Your Honor, ma'am, sir. The clear importance of the makeout session that occurred the day before the charged offense is as following. Number one, you have an affidavit from my client specifically stating that the makeout session was why he thought in part that she was ready to consent to what occurred on the 4th of May, what occurred in the bedroom, and it's why he felt that she liked him and that he could make the moves that he made in that bed, which led to consensual sexual intercourse. And you have very clearly sworn statement from the accused himself, who is subject to perjury, who is the very person that's facing a lot of time in jail here. And he has told you now definitively that this is one of the reasons why he believed that she consented. The second argument I would make would be the pure consent under B2, right, on Andrazi, which is this is similar in the sense that it is sexual conduct between the exact same people under similar circumstances in a similar location where they started to kiss and began the sexual relationship that then culminated the night before. Or the night after, the charged offense. And so to say that because they didn't have sex on the 3rd of May, that was identical to the sex they had on the 4th of May, that it's inadmissible, is in fact an unlawful standard, that is a heightened standard that's not applicable under 412. 412 does not say anywhere that, even the case law, that it's got to be the exact same sexual actions or behaviors to be admissible. it says it's got to be similar in context and substance. And so when you look at the building up process, the context of the relationship, the fact that she liked him, made out with him, that they had this initial sexual encounter, that then the next day, not a week later, not a month later, not 2 months later, not a year later, the next day led to consensual sex. Brad, reconcile those 2 points, because in my opinion, this young man may have been falsely convicted, or I should say wrongly convicted. So what does the court say about those arguments?
So I think one of the things is what you raised is similar to the appellant's counsel, is that the appellant seems to rely on Andrazi by saying that the facts that had required to be similar, but that's not what it says. It's that prior sexual activity between an accused and alleged victim is increased by the degree of similarity.
Right.
So it doesn't mean it has to be exactly the same. So nowhere in case law does it say, hey, if you kissed and this time you had sex, that it can't come in. I think, and it's hard for me to play devil's advocate because I agree with you, Rob.
Right.
I truly believe the court got this wrong. But to try and put on my judiciary hat, I think what the court really is trying to get to is, hey, defense counsel, you can't just say anything that's ever happened between two individuals is going to come in. You got to make a real evidentiary link here. So I think the real issue was there was a lack of evidence and a lack of presenting it to the actual court and an actual argument. Simply saying, hey, they kissed previously and therefore he must have had sex isn't enough. Whereas I think the judge got it wrong with the Hickeys because defense counsel did make a very good argument. He stated something to the effect of people that are being sexually assaulted do not willingly suck on their accuser's neck. And I think that's actually a really good argument.
And those are the Hickeys from the 3rd of May.
Yes, from the 3rd of May and from the 4th of May. He claims there's 2 sets. But so the judge says, hey, Hickeys from the 3rd aren't coming in. Hickeys from the 4th are if evidence comes in to show that it came from that incident.
And so with that ruling about the Hickeys, if evidence comes in to show, well, was the alleged victim, was she saying that no Hickeys occurred and that was the issue there?
So it doesn't come up clearly in the record, but that is my understanding, that she was saying that to some extent that's not what happened because otherwise she would have testified to that. But you had 2 witnesses based off of the record that testified at a motions hearing that says we saw Hickeys on Special St. Jean the next day, but it doesn't appear at trial that these 2 individuals were called in any way to testify to that. So it appears that the defense counsel was left with a no, I never sucked on his neck, never gave him Hickeys, and didn't do anything about it, which then places the trial judge in a position to say, well, there's no evidence here, defense counsel. What are you doing about that?
So let me ask this, Brad, then. At the trial level, was the defense counsel allowed to cross-examine on the Hickeys from the day of the offense itself, the alleged offense? Because that's clearly res gestae, that's not 412. Were they allowed to cross-examine on that point? Okay, got it. That's so we've got there.
It appears so because it says that when they started to go down that line of questioning, trial counsel objected because it appears that what defense counsel was trying to do is say there's 2 sets of Hickeys. What they should have done, based off the record, and it's hard, we don't have the full. What they should have done is narrowed it to Hickeys after.
Correct. That's right.
And that's what caused the issue.
And so, Brad, if she gets up there and if the questions are asked, because it's purely res gestae, we have a right to argue consent. That is a defense for nearly every single charged offense under Article 120 is consent. And so, Your Honor, the Hickeys themselves from 4 May is evidence of consent. That is evidence that she was actively participating in the sexual behaviors. She's cross-examined on that. She says, no, I never gave him Hickeys. At that point, I mean, please tell me that you agree with me. They would have been allowed to call those 2 witnesses to say, yeah, we saw Hickeys the next day on his neck. I mean, right? And so what then, just clarify for me this. At trial, when the defense counsel started to cross-examine on the Hickeys, the judge, there's an objection, and the defense counsel just moves on and never comes back. And you're saying had the defense counsel come back and crossed her on the existence of the Hickeys, they would then have been able to call the 2 witnesses. Is that the idea?
That's what it seems to be, is that the trial counsel objects and the judge says, hey, what evidence do you have? And defense counsel thought to explain there were 2 sets of Hickeys. hickeys from the alleged incident, and that was arrest yesterday and before. Trial judge says, okay, well, where's any evidence of that? And instead of saying, we'll call, proffer, Your Honor, we'll call, Specialist Snuffy and Specialist Jones, to the stand later on, they simply said, Your Honor, I can move on from this and I could possibly redress it later if the evidence is presented on that, end quote.
But wouldn't the evidence be the cross-examination question and then her denying it and then that bringing on the two witnesses? In other words, was he barred from asking the question? Because that seems very improper to me.
It doesn't seem that he was denied from asking the question. It's hard to say. I think he was denied from asking about two sets of hickeys because the judge already said the first set wouldn't be allowed. I think what it was is, and it goes again to our practitioner tip that you and I will talk about, is words have meaning. Say what you mean and mean what you say. By saying sets of hickey rather than a hickey the next day, it now opens the door. It changes the scope of what was allowed and not allowed, is my interpretation of it.
The specificity matters. And I know we're coming up on time here, but, I have two questions for you, Brad. Number one, does St. Jean serve as a bar to prior sexual contact or behavior between the accused and the alleged victim? Answer that question first. How do you, if you're a defense counsel listening to this and you have evidence that's similar, where they're making out in a bed the night before an allegation takes place, how do you argue that now? Because to me, it's unconstitutional to simply say St. Jean is a bar to prior sexual behavior.
Well, remember, this judge determined that. It doesn't mean that's never coming in. It's still an abuse of discretion. So what you need to do now is you need to articulate how the specificity, how these two instances are the same, or how it carried on from the kissing too. So maybe it's kissing and they continue texting throughout the day and flirting and making plans to show that there's never been a break. You need to link the two. But St. Jean does not deny that or does not bar that. This judge determined there wasn't similarity, and all the CAF court held, was that he didn't abuse his discretion. They didn't say, yep, we agree. Kissing one day does not mean sex the next. It says, hey, there is dissimilarity. And because you agreed to kiss doesn't mean you agreed to have sex. So we agree the judge should not abuse his discretion, but did not ultimately say you can't bring in anything prior. They simply do not state that.
So last question, Brad. Let's say we've got a brand new captain who's been TDS for 2 weeks and he's been put on a sexual assault case where he's got facts like this, where there's some sexual behavior beforehand. What are the kind of the one or two or three things that you would recommend to that individual officer in either preparing 412, arguing 412, or getting ready for, like an Article 39 alpha motion?
Absolutely. So I think the first is, and I'll break it down into four big ones, is be able to show how the instances that you're trying to point out, whether it be before or after, how are they connected to the allegation? Why are they relevant and material? Don't just say, hey, they held hands a week ago and therefore they had sex this day. Be able to specifically articulate it. So truly practice that. Think to yourself, whether you go for a run, whether you're walking your dog, whether you're making dinner, truly think to yourself, how are these two connected? The second, have evidence. So it's great to have an affidavit from your client at an Article 39A. But if you don't plan on calling your client at the trial and the victim says no, well, now you don't have any way to enter it. So you need to understand, how are you going to actually get that evidence in at trial? Because the trial is different than the motions hearing. The third, and I think something the defense counsel may have failed here, is if you're unsure about a ruling, seek clarification, right? If you're at that Article 39A and the judge rules or issues their published ruling later on, and you're unsure, get clarification. You do not want to be walking into battle unsure of the landscape. Make sure you know what is allowed and what is not allowed. And if you got new evidence, if you're unsure, if you think the judge got it wrong, ask for reconsideration. And then the last tip I would say is, if you're in the middle of your cross-examination, hopefully you don't have to do it in the middle, and the judge rules something of this nature, it's likely outside the presence of the jury, and the objection is sustained, and you get flustered, you feel like the judge got it wrong, ask for a break to regroup. Think about how you can get back on track. Don't just simply move on. Never just waive an issue that you think is important to your trial. You need to know what is a must and what is a want. And something like this, having history of kissing, having history of pickies, spending the night together, those are must-haves in a sexual assault allegation. And those would be my four. Make sure you have a plan of attack at every step there.
Very good, Brad. I think that was outstanding. I appreciate it. I think Specialist St. Jean was wrongfully convicted, and so I think your points are a good one. I'll go ahead and turn it over to Matt to close us out.
Yeah, great analysis, guys. Great show. I know a lot of the practitioners out there will really like it. And Brad, your practice points at the end were phenomenal. So thank you again. We appreciate it. We're going to wrap this one up because we've gone over the time that we had budgeted for this. But a great episode. And to all of our listeners, thanks for tuning in. Until next time, take care and be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.